Good afternoon, everyone. You hear me, Miss Bridgewater? Let's see, I can't hear you. Let me.
Yes, Shimona, we can hear you.
Oh, okay. All right, thank you. Thank you, Miss McLeod. I appreciate it. We have first courtroom two.
Stand by, Judge.
What number?
Hold on. Where's the Brian? BRY. He's position number 2.
All right, number two, who's number two?
Okay, good afternoon, ladies and gentlemen. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. If you do not have a private attorney this afternoon, we're offering you the assistance of a public defender if you choose to utilize their service. Ms. Bryan, good afternoon. You have been charged in case 25 CR 001266F with terroristic threats and acts. It's my understanding that this is Ms. Bryant's first arrest. Good afternoon, Ms. Allen.
Good afternoon. This is an incident that took place in August of this year. A warrant was obtained in October of 2024. Excuse me, when I say this year, I'm still not quite with us, 24, 25. So August of 24 is the incident date. Warrants were obtained in October of 2024. And Mrs. Bryan was just picked up in East Point this weekend. I've been in touch with her counsel, Mrs. Tevis here, and we've actually entered into a consent bond that was sent over to you this morning. We're asking for a $2,000 SOB through the jail. There is already an order in place requiring no contact with the victim, Allison Kearney, Kearney. And we're asking for no drugs that are unprescribed, no communication, obviously, with the victim, to complete that anger management, and no drugs or no firearms or weapons, Your Honor. The incident involves a phone call that was recorded and then reported to police, including threats to beat up the victim. This involved a love triangle and a period of time where there were some issues ongoing that have since been resolved. Thank you.
Very good. That's your understanding, Attorney Tevis?
Yes, Your Honor.
Very good. Ms. Bridgewater, do you have that consent for me? For some reason, we can't hear you, Ms. Bridgewater. Okay, I'll let you get yourself together there. Let's see. Shake your head. Have you gotten that from them or not for me? No. Okay. So you will get that to Ms. Bridgewater. She'll
I'll send it directly to you.
Okay. Very
Okay.
good. Thank you. Anything further this afternoon, Ms. Tevis?
No, Your Honor. Thank you.
Oh, you're welcome. You have a good afternoon and good luck to you, Ms. Bryan. Who do we have next?
15, Mr. Will Hoyt.
Say it again for me, please.
Number 15, Mr. Will Hoyt.
Okay.
Good afternoon, Judge Jason White here for Freddie Wilhoit.
Yes, good afternoon, Mr. White. Good afternoon, Mr. Will Hoyt. You have been charged in case 25 CR 001265G with failure to obey police officer, fleeing or attempting to elude, hit and run, and hit and run. Is there a history, Mr. Howard? Good afternoon.
Hey, I got a question real quick. For the last case, we just write consent bond on the calendar?
They'll get me the consent, Mr. Howard. Anything else you need to know from it, just let me know and I'll get it to you, okay?
All right. Third arrest, 08 kidnapping, false imprisonment, battery. It was dismissed. That's all.
Yes, Ms. Allen.
Thank you, Your Honor. This is an incident from the 9th. So 2 days ago, March the 9th of 2025, at about 2:18 p.m., officers were responding to an accident with injuries. They went to the location of I-66 West. This is in East Point, I believe, where an overturned vehicle was on the left side of the shoulder, and officers were on scene going to render aid and looking for other cars that were involved. So traffic was stopped on I-66 West when officers observed a Ford truck, an Echo line being driven by the defendant, strike the rear end of a white Hyundai, causing it to flip over. It then struck another vehicle, causing 2 other cars to be hit. Officer Mosley saw the driver of the Ford truck, the Econoline, and told them to go over to the side and wait. The truck that the defendant was driving was actually seen trying to go around the vehicles that they had struck. It looked like the defendant was going to comply as as officers were speaking to one of the victims in one of the vehicles. They noticed that the defendant had fled, had never gotten out of his truck, and was seen going down towards the Campbellton Road and Greenbrier exit. Officer Mosley got into his vehicle and pursued, and then did a traffic stop there at the exit of Campbellton Road. The defendant was given directives to put his vehicle in park and put his hands out of the window, and at that point he complied. So obviously multiple vehicles involved in an accident where the defendant was partially to blame, and the instigator of at least the second portion of that accident that was viewed by officers on scene. He was directed to pull over and stop as is required, and is now in violation of the hit and run statute. He fled from that scene after being told and directed by officers to go to the side. Your Honor, we're asking for a $6,000 surety. This could end up being a serious injury by vehicle. We don't have enough information yet at this point to determine what kind of injuries the other people, at least 3 other cars, experienced as a result. I know the defendant in front of you was taken to the hospital and released before he was brought to the jail. We'd ask for an order, no drugs, alcohol, or weapons, no contact with any victims as it pertains to this incident. Maybe there's going to be some civil issues moving forward, and no driving unless the defendant has the proper license, registration, and other requirements. Thank you.
Judge, Mr. Wilhoit is 71 years old. He's retired. He's a retired welder. He still does some welding. They live in Douglasville, Georgia. He has 0. I believe pretrial services said he had a criminal history. I don't believe that's accurate. My understanding is that he does not have a criminal history, but if it's on the GCIC, I'll have to address that at some point in time, Judge. But he has no convictions for anything. He also does suffer from some medical issues. He was hospitalized right before this incident, and I think that might have come into play in this case from what my understanding of the facts are. And I've also been given some medical records that indicate there could be some issues that way. Judge, I'm just going to ask for a $5,000 good bond. The conditions that the state laid out is fine, but just a $5,000 good bond, Judge.
Your Honor, just briefly, while the defendant has no criminal convictions, he's got a pretty serious driver's history, including a November 2024 improper lane change that resulted in an accident. He pled nolo in Douglas Municipal Court. 2021, 2019, 2013, and 2005. They go all the way back to 1989. But ultimately, we've got at least 3 accidents as a result of failure to yield from 2004, 2009, and 2014. So just months ago, there was an issue. The state would argue that maybe the defendant is not in a position to be driving a vehicle.
Judge, you're on mute.
Thank you. For each charge, it'll be $1,000 good bond. which makes for a total of a $3,000 good bond, a defensive driving class, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Wilhoit.
Thank you, Judge. And
You're welcome.
that concludes my business. May I be excused?
Yes, have a good afternoon, Mr. White.
Thank you,
Thank you.
Judge.
Judge Morrow,
Yes, Ms.
you can hear
Bridgewater.
me now?
Yes, ma'am.
Okay, very good. Let me tell you that the reset date for the SAP calendar is March 25th.
325. Thank you.
You're welcome.
Yes, who do we have next?
Ms. Baker?
And this is Michelle Baker, position number 1, I believe. Good afternoon, Ms. Baker. You have been charged in case 25CR001259E with battery family violence. It's my understanding that this is Ms. Baker's first arrest. Good afternoon, Ms. McConkey.
Good afternoon, Your Honor. This incident happened yesterday at 317 Skipper Place Northwest in Atlanta. The victim in this case is Mr. Randall Martin. Officers received a call to the incident location from a female caller who stated that a male at the location had a cut on his arm and was bleeding out. When they arrived, no one was there, but they did note a significant amount of blood in the breezeway of that apartment complex, as well as blood on the floors of the apartment and a broken glass coffee table. Officers then received a call from Grady about a man with an injury to his arm who was from the same location they were dispatched to. When officers arrived at the hospital, both parties were there and they spoke with the victim. Stated the parties were having an when the defendant kicked him, causing him to trip, he then fell on the glass table and cut his arm. Our office has spoken with the victim, Mr. Martin, who confirms him and the defendant are in a relationship. They live together at that location and share no children. He states the defendant pushed him, not kicked him, and he fell onto the glass table. He told our office he doesn't want to press charges, that he had to get surgery due to an artery being cut. In the jail calls between the parties, he did tell the defendant that he can't move 2 of his fingers at the moment. He told our office nothing like this has ever happened before. He states that he does want contact with the defendant and does want her to return to the residence. Given that this is her first arrest, the state's recommendation is for a signature bond, no further violent contact with the victim on the condition that she undergoes an FVIP or that she takes a few days of anger awareness, no drugs, weapons, or alcohol while out on bond. And I would ask the court to sound for Mr. Randall Martin. He's still in the hospital, so he may not be here.
If Mr. Martin's on the line and wishes to address the court, now is your opportunity. Mr. McLean?
Signature appropriate. We agree. First offense, high school education does work. Your Honor, we leave, of course, the any classes up to the court's discretion. It's a serious injury, what it is, or first offense. Thank you.
Okay, it'll be a $3,000 signature bond through pretrial level 1, 1-day anger awareness, no further violent contact with Mr. Martin, no drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Baker.
Number 7, Ms. Mahoney.
Good afternoon, Ms. Mahoney. You have been charged in case 25CR001260J with battery family violence. It's my understanding that this is Ms. Mahoney's first arrest. Yes, Ms. McConkey.
Yes, Your Honor. I have that this is her second arrest. I have that she has a 2022 conviction for disorderly conduct, which she pled NOLO for. This is also a dual arrest with position number 8, Mr. Rondricio Mahoney. This incident happened on March 10th of this year at 1926 Lathrop Street, Southwest in Atlanta. The victim, of course, is her brother, Mr. Mahoney. The parties do live in the same residence. The parties were having an argument about Miss Mahoney's dog's feces being on the ground. Miss Mahoney states that during the argument, her brother, Mr. Mahoney, began to punch her in the face. She did suffer a laceration to her chin. Mr. Mahoney states that during the argument, the defendant began pointing her finger in his face, and then she smushed her finger into his face And at that point, he did hit her to create some distance. The parties then began fighting until their younger sibling, Mr. James Hayes, stepped in to separate them. Mr. Mahoney did suffer a minor bruise to his hand that he stated came from him hitting his hand on the bed frame during the altercation. Their younger brother, Mr. Hayes, told officers that he didn't hear anything that led to the altercation, but he did witness the two parties hitting each other when he went to intervene. The recommendation for Ms. Mahoney is a signature bond. No further contact with her brother. I will defer to the court regarding any stay away. We, of course, don't know the siblings' wishes in regards to contact, which is why we're just asking for no further contact at this time, that she undergo some anger awareness, no drugs, weapons, or alcohol while out on bond.
And who's representing Ms. Mahoney?
I do, Your Honor.
Okay, yes, Mr. McLean.
No objection to the signature bond. We agree. We agree with the court has the discretion as to anything else.
Okay, Ms. McLeod, are you representing Mr. Mahoney?
Your Honor.
And what is his desire as far as contact goes?
He definitely wants to have contact with his sister. He says they're siblings. They've been living together forever. This is not something that happens with them. It was just an unusual situation. He tells me that he loves his sister and wants to have contact, Your Honor.
Okay. So for Ms. Mahoney, it'll be a $3,000 signature bond through pretrial level 1 day anger awareness, no further violent contact with Mr. Mahoney, no drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Mahoney. May we have Mr. Mahoney next, please?
Yes, sir.
Thank you.
Yeah. Okay.
Yes, good afternoon, Mr. Mahoney. You've been charged in case 25 CR 001261A with battery family violence. It's my understanding that Mr. Mahoney had one previous arrest that was of a fray and simple battery that was dismissed. Anything further, Ms. McCockey?
No, Your Honor, we would just ask for a similar bond for Mr. Mahoney as well.
Okay, Ms. McLeod?
We're fine with that, Your Honor, and with no further violent contact.
Okay, very good. As such, it'll be a $3,000 signature bond through pretrial level 1 day anger awareness, no further violent contact with Ms. Mahoney, no drugs, alcohol, weapons while out on bond. Good luck to you,
Thank you,
Mr.
Your
Mahoney.
Honor.
You're welcome.
Number 10, Ms. Roger. Oh, no, wait, I'm sorry. Number 16, Ms. Woods.
Okay. Good afternoon, Ms. Woods. You have been charged in case 25 CR 001256J with false report of a crime and failure to obey signals or control devices. It's my understanding that this is Ms. Woods' first arrest. Ms. Allen?
Thank you, Your Honor. This is the defendant's first arrest. She's got criminal or driver's history, failure to appear in 2019 and a suspension. That was a failure to obey signs. 2019, failure to yield, which is a guilty plea. Failure to yield in 2015 and followed too closely in 2014. The police were called on March the 3rd at about 10:45 in the morning by the defendant, who filed a report and said that she was the victim of a hit and run. Police were dispatched to the intersection of Medlock Bridge Road at Old Alabama Road in Johns Creek, and there they made contact with Mrs. Woods, whose car was on the right shoulder of the vehicle with the hazards on. She told the police that at the intersection, someone driving a truck, she gave a description of the truck, but said she didn't have the tag information, struck her on the front passenger corner of her vehicle and then left, continuing south, and she asked for a police report. Follow-up investigation was done, traffic cameras covering that intersection at the time period show her heading south through that intersection. She was in the right turn lane only lane, and then she goes straight and leaves that lane instead of turning right, going straight through the intersection. Halfway through the intersection, she turns her hazard lights off, or turns her hazard lights on, excuse me, and then stops just south of the intersection on the right side of the road. There's no collision. The vehicle she described striking her was not seen. She gets out of her vehicle, looks around her car, and then gets back into her vehicle. Flock cameras were also used in and around the area. In February, so February the 28th, her vehicle was shown by McDonough Police with the damage on the vehicle, but 27th, this day before, February the 27th, there was no damage. It was captured by Douglas County Sheriff's Office cameras. So obviously the damage to her vehicle occurred on the time period between February 27 and 28, and not there on Medlock Bridge Road at Old Alabama on the 3rd of March. She filed a false police report, and she also failed to obey the signs there at that intersection that was captured on the surveillance cameras. We're asking for a $4,000 SOB through pretrial, no drugs, alcohol, or weapons, and we would ask that she only drive if she has the proper licenses and registration for her vehicles, etc. Thank you.
Okay, who's representing Ms. Woods?
I am, Your Honor.
Yes, good afternoon, Ms. Madison.
And obviously we would consent, Your Honor.
Okay, it will be $1,000 signature bond through pretrial per charge, makes for a total of a $2,000 signature bond through pretrial level 1. No driving without valid credentials, no drugs, alcohol, weapons while out on bond. Good luck to you. You're welcome.
We go to ACDC.
Okay.
Good afternoon, Your Honor. Before you is petition 13.
Okay. Good afternoon, Ms. Tanku. You have been charged in case 25 CR 001268H with battery family violence. It's my understanding this is her first arrest. Ms. Allen?
Thank you, Your Honor. You're correct that the defendant has not had a arrest history. This is an incident from the 9th of March at about 1:30 in the morning. Police were actually called to the hospital, the Children's Hospital, where they met with a social worker, Mrs. Whitehead, from DFACS. She reported that the victim, in this case, a 12-year-old juvenile with the initials JT, was there at the hospital receiving treatment for a laceration on her forehead that required stitches. Her mother, who was there with her, is the defendant, and the injury was caused by mom striking the child with a broomstick in her head. The defendant spoke with police and said that she had taken her child's computer and candy from her, and the child began throwing items in her bedroom. Mom went to investigate, and her child lunged at her, so mom took a broom and struck the child in the face with it. The victim was crying. She asked, for help. Mom tended her injuries and then called her own mother, Mrs. Carolyn West, who I believe is on our Zoom. Mom reported that there is a diagnosis, and she reports that there are constant issues with the child. The child was released to grandma. We did speak to grandma, Carolyn West. She said that there is DFACS involvement right now. The child is with her, and they've been told that the child needs to remain with grandma for the next 5 days. We're asking for a $5,000 SOB through pretrial, Your Honor, to comply with any DFACS orders as it relates to this incident. No violent contact with the child, initials JT, and no drugs, alcohol, or weapons while on bond. And if you'd call for Mrs. West, thank you.
Yeah, my name is Steve West, and I represent Ms. Tanku. In full candor, she's my sister. I was at the hospital on the night of the alleged incident, and Ms. Whitehead from DFACS, in my understanding, intended to send child and mother home together, with the caveat that grandmother spend the night on that night. There is no criminal history. This is an incident when the child was acted as the aggressor, and Ms. Tanku defended herself. She's a lifelong Atlanta resident. She's gainfully employed and has been since finishing graduate school. We'd ask for a signature bond. We'd ask for a no violent contact provision if the court chooses to enforce any type of contact provision in this case.
Good afternoon, Council. It's my understanding that DFAX is involved in the matter. Is that correct?
Is correct.
Okay. As such, it will be a $3,000 signature bond through pretrial level 1. Comply with all DFAX orders. No further violent contact with the juvenile, and no drugs, alcohol, weapons while out on bond.
Thank you.
Okay. You're welcome. Good luck to you all.
May I be excused?
Yes, have a good afternoon. Thank you.
Thank you.
Thank you, Your Honor. May we be excused also?
Yes, Officer Milton. We'll see you next time. Thank you.
All right, we got next, we add on to Ms. Pickett.
Okay. Good afternoon, Ms. Pickett. You have been charged in case 25 CR 001263F with 2 counts of battery. Is there a history, Mr. Howard?
14, 2020 probation, 2019 disorderly conduct conviction, 2017 ag assault first offender, 2016 battery DV first offender. That's it.
Ms. McConkey?
Yes, Your Honor. This is an incident that occurred at 50 Mount Zion Road in Atlanta. The victim in this case is Miss Shania Pope. The victim told officers that she had dozed off in her car when she was woken up by the defendant, who dragged her out of the car by her hair, pulling out one of the victim's braids, and then began punching her in the face, causing redness to the victim's right eye. The victim was having issues with another individual by the name of Mr. Samuel Farley regarding $3,000 that he thought she stole from him. So it's possible that this incident has something to do with that. According to the report, after the defendant dragged the victim out of her car and began striking her, that individual, Mr. Farley, and another person then got in the car and drove the car away. The car was eventually found unoccupied. The state's recommendation, given the allegations in this case, as well as her history, which includes violent convictions, it's a $3,500 surety bond, no further contact with the victim, no drugs, weapons, or alcohol while out on bond. It's my understanding that the victim does not live in this apartment complex. That's why we're not asking for a stay away. I would ask the court to sound for Miss Shania Pope.
If Ms. Pope is on the line and wishes to address the court, now is your opportunity. Yes, Mr. McLean.
Thank you, Your Honor. Rhodesia Pickett is from Georgia, from Atlanta. Her cousin's here. I don't know if he's on Zoom. Her education is high school level at Athens, Georgia. Her job is making ads for a company regarding car sales, and before that she worked in DoorDash, and she's had several good jobs that were steady through the years. We would ask the court to consider a signature bond if possible, and a $1,000 surety bond if not.
Okay, for each charge, it'll be a $2,500 signature bond through pretrial level 2. Makes for a total of a $5,000 signature bond through pretrial level 2. 1-day anger awareness, no further contact with Ms. Pope, no drugs, alcohol, weapons while out on bond. Good luck, Ms. Pickett.
We do add on one, Mr. McPherson.
Good afternoon, Mr. McPherson. You have been charged in case 25 CR 001262G with battery family violence, 2 counts of cruelty to children in the 3rd degree, and possession of marijuana less than an ounce. Is there a history, Mr. Howard?
Yeah, 11 total on probation, criminal attempt to commit robbery. Also on probation for theft by receiving, possession of a firearm by first offender. So we got 2021 probation, 2019 probation. He got a lot of probation violations. 2016 FTA.
Cocky?
Yes, Your Honor, this incident occurred on the 9th of this month. I have the incident location is 3250 Dodson Connector in East Point. The victim is Jocelyn Jones, who shares a child with the defendant. The parties were having an argument because the victim asked the defendant to watch their baby, a minor with the initials GM, and the defendant didn't want to. The defendant told officers that the victim was the initial aggressor and was pulling his clothes and throwing liquor bottles at him, and that is why he struck her. The victim told officers that during the argument she was having with the defendant, he pushed her and then she proceeded to push him back. She states that she did throw a bag of cookies at him, and that is when he struck her in the face, causing a laceration to her forehead. The incident did occur in front of two minor children. Officers did note electronics and clothing scattered in the back lawn, and the victim told officers she threw the belongings outside because the defendant was refusing to leave. While conducting a search, officers did find 3 bags of marijuana in the defendant's pockets. The defendant told officers that he felt like his hand was broken from striking the victim, so he was transported to Grady. Our office has spoken with Ms. Jones, who says her and the defendant are no longer in a relationship, but they do live at that incident location and share one child. She confirmed the events in the warrant, stated nothing like this has ever happened before, that she's not in fear of him and wants to continue contact and is okay with him returning to the residence. The state's recommendation for Mr. McPherson is a $2,000 surety bond. At this time, we are asking for no further contact and a stay away. This incident did happen recently, and it is concerning that the defendant struck the victim so hard that he thought he had broken his hand. We would ask for no drugs, weapons, or alcohol while out on bond. In a day or two of anger awareness, I would ask the court to sound for Ms. Jocelyn Jones.
Ms. Jones, I see you on the line. If you would like to address the court, now is your opportunity to do so. Of course, do not have to, but if you would like to, I'll need for you to unmute yourself, activate your camera, and I'll have to swear you in. Who wrote, Mr. McLean, is this your case?
I
My
had,
case, Your Honor.
Okay,
right. I think
yes,
that's,
yes. Thank you,
yes.
Mr. McLean. Yes, Ms. McLeod.
Your Honor, I would ask the court for as low a bond as possible for my client in the event that he does not qualify for a signature bond. Based on what my client told me, it seems like he was not the primary aggressor in all of this, Your Honor. So I would ask the court to take that into consideration. He does have a history, but none of it sounds like a violent history. And it certainly doesn't have any domestic violence related incidents in his history. So I would ask the court to take that into consideration in setting his bond. Since they share a child together, I believe no further violent contact would probably be appropriate, given the fact that that is what Miss Jones would like, and my client is okay with that as well.
For the battery, it'll be $1,000 good bond. For each of the other charges will be a $500 good bond. Makes for a total of a $2,500 good bond. At this point in time, no further contact with Ms. Jones. Stay away from the incident location. He can go back to that location on one occasion with law enforcement to retrieve any belongings. Third-party transfer of the minor child for visitation. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. McPherson.
My client told me that his family has moved his belongings, Your Honor, so I don't think the law enforcement escort will be necessary.
Okay, that's fine then. Thank you.
You're welcome.
Add on 3, Mr. Stevens.
Good afternoon, Mr. Stevens. You've been charged in case 25 CR 001246F with criminal trespass. The history for maybe just the last 10 years, Mr. Howard?
Well, this is about the last 10. You got 50 total. Open simple battery in the cab, terrorist threats in Fulton, on probation in Fulton, simple battery against police, obstruction. 2024 trespass, damage to property conviction. 2022 disorderly conduct conviction. 2022 battery conviction. 2021 disorderly conduct conviction. You want me to keep going?
Okay,
I can. I'm just asking.
no, thank you, Mr. Howard.
Okay.
I've got it here with me. I appreciate it. Yes, Miss Allen.
Your Honor, there might need to be a breakout related to this gentleman. He does have two current cases he is on probation for. The victim in the case is his sister. She has been the victim in cases with him previously, at least twice. This case deals with criminal damage to property at her address, 307 University Avenue. The defendant has already been ordered to have no contact with her and to stay away from that location. He just recently, in February on the 4th, was arrested for throwing a brick through the windshield of a motorist at an intersection downtown. I note that his 2020 cases, both felonies that were reduced to misdemeanors, required him to have mental health compliance with treatment and medication. In May of 2024, and one of the cases he's on probation for from October, which is a plea, he was ordered to undergo an MHET. So we're asking for a $2,000 surety, Your Honor. Stay away from 307 University Avenue. That's the residence of his sister and frequent victim, Rashonda Coffin, Coffen. Medication compliance and no drugs, alcohol, or weapons. There needs to maybe be an evaluation or assessment.
Was one ordered as a result of any of those previous probation cases? Do you know, Miss Allen?
The current probation, two of the cases he's currently on probation for include a MHET and staying away from the same address. Yes.
Okay, so if he has, okay, thank you. Who's representing Mr.
Your Honor,
Stevens?
Your Honor, this is my case.
Yeah. Yes.
Okay, Mr. Stevens is currently employed at Labor Ready, but he does have very, very little income. He's also residentially challenged, but he was recently accepted into an evolution program where they were in the process of facilitating him housing. He stated that he went to his sister's house to attempt to get his ID so that he could finish enrolling in the program. But that he wasn't aware that she didn't want him there. So he is in a position where he's not able to actually afford the surety bond. So we're requesting if Your Honor would consider a signature bond.
And Your Honor, just to respond briefly, you know, the defendant is absolutely clear that he's not supposed to be at his sister's residence. And if he truly is acting like he doesn't understand that, then there's even further reason for some kind of intervention here. He was described as highly intoxicated on scene. He was in possession of multiple bottles of alcohol on scene. He also had a bag of belongings with him. And police noted in their documents that they were familiar with him, that he'd been previously criminally trespassed there just on the 8th of March. And that there had been multiple prior incidences of violence and damage to the property there at the location.
Okay. I want him to go on the competency calendar. If an MHET has already been ordered, I want to know where we are with that. So, yes, Kia, do you have something for me?
No, Your Honor, I just wanted to let you know I was here.
Okay, thank you.
Thank
You let me know. Okay, I would like for Mr. Stevens to go on the competency calendar. Let's put him on the one for the 27th, Miss Bridgewater.
Yes.
I think if I put him on the competency calendar, at least that will give you all a heads up to let him to see if he has had an evaluation as of yet and maybe get him on that track. And so I'll take the state's recommendation at this point, a $2,000 good bond, no further contact with the alleged victim, stay away from the incident location, no drugs, alcohol, weapons while out on bond. If Ms. Madison, if you will make sure that who's ever on that competency calendar has information regarding this matter so that we can see if we can get Mr. Stevens some services.
Yes, Your Honor.
Okay, very good. And is that okay, Ms. Bridgewater?
It's perfectly fine, Your Honor.
Okay, very good. Good luck to you, Mr. Stevens.
Next, we got number 3, Mr. Byrd.
Good afternoon, Mr. Byrd. You have been charged in case 25 CR 001258H with battery family violence, simple battery family violence, and cruelty to children in the 3rd degree. Is there a history, Mr. Howard?
We got 11. All I saw was driving and some marijuana.
Okay. Ms. McConkey?
Yes, Your Honor. This incident happened on February 24th. The incident location is 4640 Raven Loop in Union City. The victims in this case are Erica Duggett, who is the defendant's wife, and Anaya Duggett, who is the defendant's stepdaughter. The defendant is accused of striking his wife and stepdaughter, causing a bruise to the stepdaughter's eye. This incident did occur in front of a minor child with the initials CB. Our office has spoken with both victims in this case. The defendant's wife, Ms. Erica Duggett, stated that her and the defendant lived together at the incident location. They share no children. She said that they got into an argument because the defendant accused her of cheating, and then she heard a noise downstairs and saw that glass was broken. So she called the police because she thought the defendant was tearing up the house. When the police got there, they told him to leave for 24 hours, and that's when her daughter and her daughter's boyfriend came over to help clean up the glass. The defendant then returned and got into an argument with his wife, trying to take her keys. They were tussling over her keys, and that is when her daughter stepped in between them. And she states that her daughter might have gotten hit in the midst of the tussle. She states the defendant never hit her, and they have been living together since this incident, and there has been no violence since. She's not in fear and wants him to return to the residence. Ms. Anaya Duggett states that she was trying to break up the fight between the defendant and her mother, and that is when she was struck in the eye in the midst of trying to break that up. She does state nothing like this has ever happened before. She's not in fear of the defendant and wants to continue contact. The state's recommendation is for a $2,000 surety bond and no further violent contact with the victims on the condition that he do some anger awareness, no drugs, weapons, or alcohol while out on bond. I would ask the court to sound for Ms. Erica and Anaya Duggett.
I see Erica and Anaya Duggett on the line. If you would like to address the court, now is your opportunity to do so. You, of course, do not have to, but if you would like to address the court, I'll need for you to unmute yourself, activate your camera for me.
Judge, hi, how are you, Your Honor? It's not letting me unactivate my camera for some reason. It's saying video is unavailable for use at this time. Refresh your Zoom or something. But it's letting me unactivate my mic. I don't understand that. Is there a way to get around that? Oh, wait a minute. I see. It says start my video. I don't know if that is going to work. I'm trying to start the video. It's not starting. I don't know why. It says video is unavailable at this time. Please refresh your page. Should I log back out and log back in?
For me, Ms. Erica, and while you do that, Ms. Anaya, if you would like to speak to the court, I'll need for you to raise your right hand for me. You swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Thank you, ma'am. What would you like to tell the court?
I would just like to say that I love my father and I would like him to return home. And it was just a bad judgment that day. And, I just, the way things escalated so fast and, underneath alcohol and with things involved, I was just trying to, de-escalate him from being in my, getting the keys and leaving. And it just took a worse return. And
Okay.
I would like to say that I love my father and I would like for him to return home.
Okay, this allegedly happened back on February 24th. Have you all been around each other since that time?
Yes.
Okay, and there have been no further incidents?
No, nothing like this
Okay.
has ever happened. He's raised me from birth since I was a day old.
Okay, thank you. I appreciate.
I'm sorry.
Yes, Mr. Erica, I see you
I'm
there.
here. Yes.
Okay. Hold on one second.
sorry.
No,
I'm
you're
sorry.
fine. Can you raise your right hand for me, please?
Yes.
Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, now you can place your hand down. What would you like to tell me, ma'am?
Yes, he wasn't violent, so I don't know where the big misconstrue with that got to be where they said he was violent or he didn't hit anybody. It was a tussle over the keys. I didn't want him to take my car at the time of the incident, but we have 3 kids together. So we have my daughter that you just saw and 2 sons. So they said no kids, but we've been together for 25 years and married since 2023. So we've never had any incidents. We both have been, just together the whole time until this one last thing, and it wasn't violent. I don't have any hits, bruises, scars, or anything. And my daughter stepped in between us because he was grabbing the keys out of my hand. So that got to where that's how that part happened.
Okay. I thank you both for being here this afternoon.
Thank you so much.
You're welcome. Yes, Mr. McLean.
Thank you, Honor. He's 45 years old, 12th grade education, has worked for the last 15 years at Nippon Warehouse, Import-Export. He does everything there, forklift certified, loading, unloading, light supervision of new employees, that sort of thing. We would ask the court to consider signature bond.
For the battery, it will be a $2,000 signature bond through pretrial level 1. For each of the other charges, it will be a $500 signature bond through pretrial level 1. Makes for a total of a $3,000 signature bond through pretrial level 1. 1-day anger awareness. No further violent contact with either of the alleged victims. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Byrd.
Thank you, sir.
You're welcome.
Ms. Diaz.
Yes, good afternoon, Mr. Diaz. You have been charged in case 25 CR 001255C with 2 counts of reckless conduct and possession of a pistol or revolver by a person under 18 years of age. It's my understanding that this is Mr. Diaz's first arrest. Ms. Allen?
Thank you, Your Honor. That is the case. This is an incident that occurred on the 10th of March, so yesterday, between about noon and 3 p.m. Police were called to the location, which is an apartment, 1112 Hemingway Lane in Roswell. There it was discovered that the defendant in front of you had purchased a firearm from someone that he claimed he didn't know their name. The firearm he discharged inside of the residence there at 1112. It went through the wall in the dining room area and into the next door residence sharing a wall, 1114 Hemingway Lane, endangering the people who live there, specifically the individuals Alejandro Rosas and Gilberto Perez. The defendant made up a story claiming that someone had discharged the firearm inside his residence. He then confessed that it was him and he'd hidden the firearm in a trash can. Defects were seen on the walls as a result of the firearm going through the wall and into the neighboring apartment. We did speak to the people in the next apartment. They reported that they were concerned that a projectile from the firearm hit their dining room table and a bathroom wall. There are 2 children that live in that residence. They're concerned for their safety and they're afraid that this will happen again. They want to make sure that their children are safe. We'd ask for a $10,000 SOB through pretrial, Your Honor, and we'd ask for some conditions, specifically information first about attendance in school, job, whether or not a curfew is appropriate, and obviously surrendering all firearms. There should be no firearms in the home of this young man and no drugs, alcohol, or weapons.
Ms. Madison?
Yes, Your Honor, and we would consent. Mr. Diaz has stated that he is currently in the 10th grade at Roswell High School. His mother is present on the line. He's 18 years old, and he currently works for a company called All My Sons Moving, where he, I believe, works on the weekends and I believe after school. We would consent to the SOB bond, Your Honor. With
Okay.
conditions.
Thank you. Miss Anna Chavez, is this your son?
And my apologies. I had reached out earlier, but she does need a Spanish interpreter. I'm not sure if that would be helpful, Your Honor. But I did want her here. But I reached out to the jail earlier to try to get an interpreter.
Were you able to speak with her?
Not really, Your Honor. I did let her know that she needed to be here today, that I'd be representing her son, but I can communicate with her if needed.
Okay, well, I'm going to require that she is a parental co-signer for him to get out. So we'll need to communicate that to her. So he's only going to be released into her custody. And I take it that her name is spelled correctly here on the screen here. I want him to have a curfew. He is to be in by 9 p.m. and stay in until 6 a.m. I want him to remain in school at Roswell High School. As such, for each charge, it will be a $3,000 signature bond through pretrial level 1, makes for a total of a $9,000 signature bond through pretrial level 1, with the with the parental co-signer, Ms. Chavez, and all the other conditions that I just enumerated.
Thank you, Your Honor.
Okay. All right. Good luck to you, Mr. Diaz.
Number 5, Mr. Hunt.
Greetings, Your Honor.
Good afternoon, Mr. Hun. So you've been charged in case 25 CR 001257E with driving while your license is suspended or revoked, failure to have your license on your person, possession of an open alcohol container, and possession of marijuana less than an ounce. Is there a history, Mr. Howard?
2017 driving without a valid license. 2012 marijuana. Everything else is early 2000s.
Okay, Ms. McConkey.
Yes, Your Honor. As far as his driving history goes, it looks like he has a 2023 FTA, a 2023 failure to maintain insurance, 2024 operating vehicle with a suspended license, and another 2023 no insurance. This incident is from March 10th. Officers received an alert that the owner of the vehicle the defendant was driving had an active license suspension and that the vehicle did not appear to have the correct decal on the license plate. Officers conducted a traffic stop and they did in fact confirm that the defendant's license was indeed suspended. He also did not have his license on his person. When officers tried to detain him, he was constantly attempting to pull away and maneuver his body in a way to avoid a detainment. While being placed in the patrol vehicle, a small yellow bag with an unknown substance fell from the defendant's possession and he proceeded to somehow pick it up and swallow it. He told officers that it was aspirin, while officers also noted the smell of alcohol coming from the defendant's breath. And while they were searching the vehicle, they did find an open container of Seagram's gin, as well as a marijuana blunt. The state's recommendation for Mr. Hun is a $2,500 surety bond, given the allegations in this case, as well as his history, no driving without a valid license, and the proper documentation, no drugs, weapons, or alcohol while out on bond.
McLean.
Thank you, Your Honor. Mr. Carlos Hunt is 70 years old, 30 of his years in Georgia, so he's local. He tells me he had that straightened out about his recent driving requirements, legal requirements, and he believes that it was incorrect that that his license was suspended at the time. But be that as may, he can get more information on that and do that later. For bond, Your Honor, I would note that he is a retired person. He worked in zoning in the city of Atlanta. After that, he worked in planning. He also did tax assessor's office for 4 years. And he is on a Social Security income. He has an associate's degree in building construction and architectural matters, 2-year degree in that. We would ask the court, he also lives at a high-rise senior, high-rise, and zip code 30310. With the unit number and everything, I would ask the court to consider a signature bond, Your Honor, given his stability and amenability to come to court on time. Any appropriate conditions regarding driving the court feels is right. Thank you.
Okay, Mr. Hunt, it's gonna be a $250 signature bond through the jail on each charge, so it makes for a total of $1,000 signature bond through the jail. You cannot drive a vehicle unless you have a proper driver's license, okay? So don't get behind the wheel of a car until you make sure that your driver's license is not suspended or revoked. No drugs, alcohol, weapons while out on bond. Mr. Hunt, I'm going to let you out, but if you don't show up for your next court hearing, they're going to put a warrant out for you and you're going to be right back here, okay?
Well, I'll be there.
Okay, all right. Good luck to you, Mr. Hunt.
Your Honor, I show a total of 5 charges.
Okay, I have 4 on my calendar. Let's
They had
see.
failure to
Oh,
have license on person and then that willful obstruction. They run together.
okay, thank you. I see. Thank you, Ms. Bridgewater.
Mhm.
So,
Thank you.
for the obstruction, I did not see the obstruction, so excuse me. I'm gonna have to send him through. Hold on, I'm gonna have to send him through pretrial with the obstruction. So the obstruction charge will be a $500 signature bond through pretrial level 1.
Thank you. Thank you, Mr. Driver. Mr. Mike McCain, thank you also.
So that'll make for a total of a $1,500 signature bond through pretrial level 1.
Okay.
Okay?
Mhm.
All right. Good luck to you, Mr. Hunt.
Thank you for your blessings and charity. Oh, okay.
Who do we have next?
Number 11, Mr. Rowe.
Good afternoon, Mr. Rowe. You have been charged in case 25 CR 001270J with a violation of a family violence order, driving under the influence of alcohol less safe, and possession of an open alcohol container. Is there a history, Mr. Howard?
Third arrest, got an open violation of family violence order. 25 CR 000. Oh, no, they missing a number. But it's open in state court. No matter. Battery DB 2 counts, 1 count simple battery. That's all.
And Ms. Allen?
Thank you, Your Honor. So the incident in front of you today is from the 7th of January. Police were dispatched to the residence where the victim in this case, who is the wife of this defendant, lives, and he'd been previously ordered in 2 separate bond orders to stay away from and have no contact with her there. That's 425 Rocky Creek Drive in Roswell. Since his arrest related to this incident, my understanding after speaking with the victim today, our advocate did, that he had entered into Peachford and then did some 45 days in a facility, is currently living in a sober living program. So this incident, police were called January the 7th to 425 Rocky Creek at about 10:45 p.m. The victim, Mrs. Shannon Rowe, called police. She reported that the defendant was in his vehicle, a truck parked in the driveway there. and that he was intoxicated and in violation of the conditions of his bond. The police documents include information that this gentleman was known and had been arrested previously on the 1st of January and the 3rd. When police got to the location, he was in the driver's seat of his vehicle and his car was running, and he had attached a water hose to the exhaust pipe of his vehicle with duct tape. The victim, Mrs. Shannon, reported that the defendant had previously threatened to harm himself in the same manner that police had observed the car to be set up at that time. The defendant was detained. He was obviously intoxicated. He had an open beer in the cup holder of his vehicle, a 6-pack on the floor, and an empty liquor bottle on the floor with the beer 6-pack, I believe. The victim reported that the defendant had reached out to her by text on the 7th of January, asking if there was any money on the credit card available. She didn't respond, but she did see that he'd then spent $50 at the liquor store and $70 at Home Depot. And she expressed that she was fearful he was going to harm her and harm himself. The victim also had, during the SEA proceedings on January the 4th, I believe, had recorded the defendant being told his conditions of his bond by Judge Law, and she played that recording on her phone to officers there who noted that the defendant was not supposed to be there, and he was arrested for that open container, driving his vehicle while under the influence and violating the bond order, the protective bond order again. Your Honor, the initial incident that this gentleman came into court on January the 1st included an assault with visible injuries to his wife. He was ordered by Judge Law to stay away from that location and have no contact with her. That bond order was surrendered when he was arrested 2 days later. He had been released from the Fulton County Jail, gone right back to the location. The victim called the police and said that he had been released from jail and he was there. He then fled before police arrived, and he was taken into custody after being stopped at a traffic stop nearby. This is exactly the kind of case that has a high level of lethality indicated on it. The report on January the 1st made by the victim, she not only reported being assaulted, she reported that her husband was trying to drive. They got into an argument over her not giving the keys to him. He wanted access to the firearms in the home.
Yeah, and I'm going to object at this point. I mean, he's already got a bond for that case and the other case. I think that we need to stick with the facts of this case and this case only. That's already been litigated and decided as far as bond on that matter. So I would object to that because it has no bearing on this situation right here, what we're dealing with.
It's actually very relevant.
It has zero relevance to what happened on January 1st to a DUI.
Okay, well, he also has a violation of a family violence protective order, Mr. Smith. And if you've been in my court before, you know I'm going to hear fully from you anything that you want to tell me, and I'm going to hear fully from Miss Allen anything that she wants to tell me. So go ahead, Miss Allen.
Just wanted to point out that the lethality factors in a case like this are big red flags. There is prior violence, substance abuse, access to firearms, and continued violations of court orders. So just to bring that to your attention, Your Honor, my understanding is that after the second arrest, so the 2 open cases for this gentleman, defense counsel filed in a motion to modify the bond conditions, stating that the victim in this case wanted no violent contact. Those motions have not been heard. The state's position today is that those shouldn't be heard without the victim being present. The defense attorney for Mr. Rowe can absolutely ask for a modification of bonds in the 2 cases he already has open, but to do so without the presence and input from a victim in front of a judge would be improper. And Mrs. Rowe was not available today to be on the Zoom. She's also a victim in now 3 different cases and clearly involved in a cycle that has a high level of lethality as a risk here, Your Honor. So the state's requesting the defendant now on his 2 open cases has a $2,500 good bond for the January 1st battery family violence. That's 25 CR 000024J, and has a $2,500 good bond on the January the 3rd violation of the TPO 25 CR 000091J. Both of those require that he have no contact with his wife, that he stay away from 425 Rocky Creek Drive. The first, the actual battery case involved, also requires him to enter into family violence intervention. He is not allowed to return to the property to visit. A third party has to go to the location in order to get things for him. He is also supposed to undertake an ADET and have no drugs, alcohol, and weapons. And so January 1st is relevant because the case in front of you today involves multiple violations of multiple conditions on those bonds. And we're asking for an $8,000 surety today to stay away from the location, again, have no contact with Mrs. Shannon Rowe, and no drugs, alcohol, or weapons, Your Honor. Obviously, if the defendant has entered into treatment and is living in sober living, that is completely relevant to his care and his cases moving forward. And the ability to communicate with him and defense counsel about how he's doing is something that the office, the state, clearly is interested in continuing to do for his safety, for his health and well-being, as well as that of his victim. Thank you.
Yes, Mr. Smith.
Yeah, and I have the fortunate pleasure of representing Mr. Rowe. He's 57 years old, lifelong resident of the state of Georgia. Your Honor, him and his wife have been together for over 45 years. Well, over 40 years. They've been married for well over 30 years. There is zero history whatsoever, aside from the incidents we're dealing with now in this relationship. The situations, how I understand it, is that Mr. Rowe only wanted to get, I guess, his truck from the house in order to find a hotel to get away. They did find him in his truck at a hotel. He was trying to find somewhere to stay. You're talking about somebody who's been in a residence for decades that's now saying that you cannot go back. So he was trying to find a place to stay. He has been getting treatment. He was in Dahlonega for 5.5 weeks. He's now doing follow-up treatment at Roswell at Sober Living. He's at Mount Sinai in Dahlonega. He was doing very well there. He did very well there, I should say. He's continued to do well at Sober Living. I've been in constant contact with his wife. She signed a sworn affidavit saying that she had no issues with him having no violent contact with her and had no issues of him coming home. This is a couple that's been together for an eternity. And yes, there has been some things that have occurred over the last month or so, or last 2 months, sorry. But Your Honor, I think that this is a situation that it can't be looked at as a lot of situations of this ongoing domestic violence issue, because that's just not the case. First and foremost, he's already addressed the issue of the alcohol. He's continued to address it. That's number one. But number two, as I've spoken to Mrs. Rowe, which is his wife, and I speak to Mr. Rowe all the time, it would seem to indicate to me that this was just a situation where Mr. Rowe sounded like he misunderstood what he was trying to do as far as going back to get his transportation. And going back to do that, obviously 911 got called and we got to this point. I don't think there's a situation where he's stalking her, where he's sitting outside. He hasn't been to the house since his last arrest. He was not arrested on the third issue. It was my understanding that the second one happened altogether, but they just put a warrant out for his arrest later for the DUI. And so I have to look into that because I didn't realize it was two separate issues. It was my understanding it happened on the same evening. It's just that a warrant was never issued until later because he already bonded out twice. When we found out there was a warrant, he voluntarily turned himself in yesterday, and now we're here today. I think $8,000 is very high for Mr. Rowe, who doesn't necessarily have a history of this, but as you can see, all this happened within a span of 1 week. And so when the warrants went out for the DUI, I was in contact with the city of Roswell They let me know what was going on as a courtesy. Once I found out, then we made the proper amends for him to come turn himself in voluntarily. Miss Rose signed an affidavit. I filed that with my motions. I've asked the court to be heard on those motions. I just spoke with her right before court. She's available to get on Zoom if the court needs her and talk to the court. So I would attest that she is available. She spoke with the victim advocate today, and she said the exact same thing I'm saying. That she has no problems with him coming back home, and she has no problems with having contact with him, so long as he's getting the treatment, which he is doing. So I would ask the court to allow him to have no violent contact and allow him to go home once his treatment is done. This second half of his treatment is probably going to last another 2 or 3 months. He's already been in treatment now for right at 2 months. So we're talking May or June before he's even released from the treatment that he's in now. So about 6 or 7 months of treatment. It's a good sign that he's taking care of business, but I don't think this is a situation where we have this long history of domestic violence on something that happened within a couple days of each other. Again, he's addressed his issues. He's going to continue to address the issues. And I believe that this couple that's been together for a very long time is ready to get back together, but obviously his bond conditions do not allow that at this time. So we're asking the court for a reasonable bond in his case, and we're also asking the court to allow him to be able to go back home at some point when he gets released and allow him to have contact with his wife, with no violent contact with his wife as he stays in the facility. He has nobody else to talk to but me, and his wife has been by his side for almost over half of his life. And as of right now, it would seem to indicate to me that the situations that were that arose in the beginning of January are not the same situations as we see here in the middle of March. So I'm just asking the court to allow him to have some sort of contact with his wife and for him to be able to go back home once he's done with treatment.
Okay, well, I'm only going to address this bond today. I'm not going to address modifications of other bonds that were not given by me. And just so that your client understands, until a judge deems it fit to modify a bond, then that bond is not modified. So
Correct.
that means that if another judge has said that you're to have no further contact, I know that I go into contact, especially what no contact means. I'm sure that Judge Law does that, and I'm sure that she does it very specifically as to what that means. It's also concerning to me that that his wife deemed it appropriate to call 911 when she saw him, as you say, get in his truck or whatever. She didn't. So there's something more going on here, is all I'm saying. And so if she feels differently, then have a hearing on it and let a judge determine that modification. But he's not to have any contact with Ms. Rowe until the bonds are modified, and that's this bond as well, because I'm going to put the same no contact in this bond. No contact means absolutely no contact. No phone contact, no personal contact, no internet contact, no social media contact, no contact, no going just to pick up a vehicle, no going to pick up a watch, no going to pick up anything without a specifically deemed third-party police escort if that was in the order. So, and if that was in the order, that means that he knew that he wasn't supposed to be going there without without an officer. So you just can't show up, and that I think it's I think we make it very clear that when there's no contact, that you just can't show up. As far as this bond goes, for the violation of the Family Violence Protection Order, it's going to be a $2,000 good bond. For the DUI, a $1,500 good bond. For the possession of an open alcohol container, a $500 good bond. Makes for a total of a $4,000 good bond. At this point in time, no further contact with Ms. Rowe, no drugs, alcohol, weapons while out on bond. I'm not sure where your motions, Attorney Smith, are appearing. If he does not get out of custody by my SAP calendar, which is in 2 weeks, I'm happy to consider those at that calendar. If he gets released, then you're going to have to take all these bond modifications up with the division judge where the case is pending.
I can
Okay?
assure you, Your Honor, he's not going to be released by that time. He'll still be in.
Okay, well, my SAP calendar council is on 3/25. I would suggest to you that you get in touch with Miss Allen's office and that you all get Miss Rowe at that hearing. I'm happy to hear a bond modification on that date, but as Miss Allen said, I will want to hear from everybody that it is directly affected, which certainly means Miss Shannon Rowe. Okay.
Is there a date directly after that? I'm in trial that week. So I'm going out on a trial. I will not be available on the 25th.
Okay, well, that's the date that it'll be on. If you want me to put it on another date, once it's on that calendar, if you'll file a motion, then it'll be placed on another calendar if you choose.
Sounds good.
All right, very good. Good luck to you, Mr. Rowe. If there's nothing further, Attorney Smith, you have a good rest of your afternoon.
All right, y'all too. Thank you.
You're
Your Honor,
welcome.
will you repeat those bond amounts again, please?
I will. 2,000 for the violation of the family violence order, 1,500 for the DUI, 500 for the open container.
Thank you.
You're welcome. Okay, who do we have next?
Well, Mr. Simpson.
Okay. Good afternoon, Mr. Simpson's position number 12. Good afternoon, Mr. Simpson. You have been charged in case 25 CR 001269F with battery. Is there a history, Mr. Howard?
Third arrest, 2020, carrying pistol without a license. 2012, possession of marijuana, resident of Alabama.
Okay, Ms. Allen.
Thank you, Your Honor. This is an incident from June of 2022. Warrants were issued at that time. The incident was reported near the area of Fulton Industrial Boulevard by a coworker and the victim in this case. She reported that she and the defendant had driven here together from Alabama. She'd asked him for a ride. They both have family here, and so they had driven with the defendant driving her. The day before, she had spent the night at her sister's house. He spent the night with a brother, and they had connected again the next day in order to return home. The victim's name is Jaycia Laster, Jaycia. When she called police, the open line captured altercation between her and the defendant. She reported that she was being assaulted inside his blue Honda. And then police weren't able to get her back on the line. Officers responded and didn't see the blue Honda, but located her sitting on the curb near the BP there at Campbellton Road. She reported she didn't even know the name of the road she was, sitting on the curb of, but she had visible injuries. She had bruising and swelling to her face, and she reported that to her words specifically were, he must have gotten up on the wrong side of the bed this morning, that the defendant had picked her up for them to go home, and he became aggressive with her. He grabbed her by her neck and he punched her in the face and then forced her out of the vehicle. She then provided a copy of the driver's license for this gentleman. And the reason we're able to move forward today, given that this is a 2022 case, is because she and the defendant both are residents of Alabama, and that tolls the statute of limitations. The defendant was not here in order to answer for his charges between the 6th of, or June, excuse me, of 2022 and March the 10th when he was picked up by GSP troopers, I believe, on that outstanding warrant that's been present in the system since June. So we're asking for a $2,000 surety, Your Honor, to stay away from the victim in this case, Mrs. Laster, no contact with her, and to stay away from wherever she lives or works, and no drugs, alcohol, or weapons. We did try to get in touch with her today, but we hadn't been successful yet. We'll continue those efforts. Thank you.
Okay, Ms. Laster is on the line and wishes to address the court. Now is your opportunity. Ms. Madison.
Yes, Your Honor. Mr. Simpson informed me that this was a situation where both parties traveled together from Alabama to here. And on the specific date of the incident, my client had been driving the alleged victim around for several different places. And when he refused to take her to the final location, she grabbed the wheel of the vehicle and kind of tried to run the car off of the road. And so he ended up putting her out of the vehicle, but at no point did he ever punch her or strike her or attack her in any way. Your Honor, we are requesting that you would consider a signature bond. He is originally from Atlanta and he has a lot of family still here. He currently works as a buffer at Fox Factory. He has very little income, but he has been working there for several months. So he does need to get out of jail so that he's able to maintain his job. So, Your Honor, we are requesting a signature bond as he's not able to afford a surety bond at this time.
Who is Miss Laster to Mr. Simpson?
I believe they worked together. They were never romantically involved in any way, shape, or form, although he doesn't have any issues staying away from her.
Okay. It's going to be a $500 good bond. No further contact with Miss Laster. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Simpson.
Sir.
Thank you, Your Honor.
Welcome.
14, Mr. Watkins.
Good afternoon, Mr. Watkins. You have been charged in case 25 CR 001267J with battery and one additional misdemeanor charge. Is there a history, Mr. Howard?
6. Last arrest was 2008. Cruising in the third, 3 counts. Battery, ag assault, terroristic threats. Those are convictions.
Your Honor, this is an incident from July, July 20th of 2024. Again, warrants were obtained after the incident and the defendant was just picked up on I-285, excuse me, on the 10th. At about 9:50 p.m. at 1115 Donald Lee Hollowell Parkway, the victim, Mrs. Aminta Brown, and that's spelled Aminita, reported that she'd been at the Maddox Park there with others from her neighborhood and people she knows when she encountered the defendant who she knows from the neighborhood, and he grabbed her bottom multiple times. She pushed him away and told him to stop. He then walked away and came back, and while she was in a conversation with someone else, he did it again, and she told him, I'm going to tell your girlfriend about your inappropriate behavior, at which point he reached out and punched her in her face in front of witnesses. She was seen to have visible swelling and bruising to her face as a result of being hit by this defendant. She identified the defendant. She let police know where he lives and the kind of car he drives, and there were multiple witnesses there. We did speak to the victim, Mrs. Brown, today. She reports that she knows this individual, but they're not friends, that he had touched her on her bottom multiple times earlier in the day, had left and then come back. He intervened in a conversation she was having with someone else. She did not like that. And then he struck her in the face. She does not want any contact. We're asking for a $10,000 surety, Your Honor. No contact, to stay away from Mrs. Brown and her residence or wherever she may work. No contact through any means. And no drugs, alcohol, or weapons. The defendant does have that 2008 aggravated assault, terroristic threats, battery, family violence, and cruelty conviction, and he's got a CWAC conviction from the 90s. The charges here are alarming and frankly describe behavior that is bold in a strange way and an alarming way. There's a concern here for the safety of this victim as well as anyone who is female that this gentleman has contact with. If you could sound for Mrs. Brown, thank you.
If Ms. Brown is on the line and wishes to address the court, now is your opportunity to do so. Madison?
Yes, Your Honor. Mr. Watkins denies any of this ever happening. It's his position that the two were involved in a verbal altercation, and due to the alleged victim feeling disrespected on several occasions, she's now had people come and attack him, bust windows out of his home, leave him with all type of bruises, damaged jewelry of his, all because she felt disrespected during a verbal altercation that the two had. But it's his position that he has never physically touched her in any way, shape, or form, that the two were long-term friends. And in fact, they're actually neighbors, Your Honor. However, he stated none of this has ever happened. We are requesting that you would consider granting him a signature bond. He has very little income. He currently works painting cars, but he explained that work has been very slow lately. He also suffers from several medical conditions, including being deaf in his right ear, as well as I believe gout. And so, Your Honor, due to him having very little income, not having been arrested in almost 20 years, him also being a long-term resident of Atlanta, Your Honor, we're hoping you would consider a signature bond.
For each charge, it will be $1,000 good bond, makes for a total of a $2,000 good bond. No further contact with Ms. Brown, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Watkins.
Thanks.
Welcome.
I'm about to get home to them pets. Oh, for the hell, Jim. It is. I think that's it, Judge.
Okay, we have some that I need an announcement on. Let's see. Position number 6, Mr. David Lowe.
We're gonna image reset.
Okay, so that's gonna be reset for tomorrow, 3/12. Position number 9, Montavious Mason.
We did that case yesterday.
Oh, we did Mr. Mason yesterday?
Yes, sir. You got $1,000 good bond on that one.
Okay, anybody want to remind me?
I don't have that calendar before me, but I remember that case, but I don't know why he's back on for today.
Let me grab my calendar.
Okay.
Okay, yes, I did give Mr. Montavious Mason $1,000 good bond yesterday. So I guess I'm not sure why he's back on the calendar. And finally, we have position number 10, Cheryl Rogers.
Your Honor, that should be a medical reset. She was complaining of not being able to move her legs, but she also seemed to be in crisis. And I would ask for the mental to take a look at her.
Okay, so a medical reset until tomorrow, Mr. McClellan?
Yes, Your Honor, that'd be good.
Okay,
Your Honor, Mr. Lowe was reset from yesterday, so this would be the second reset.
okay, so I'm not sure what's going on with Mr. Lowe, but let's see if we can get him tomorrow. Okay, I think that covers it, Miss Bridgewater.
Yes, sir.
For me. And I'm not sure, someone has chatted something that I'm
reading that as well.
I can't decipher it, so maybe somebody else can.
Okay. Okay, once again, the reset date for the SAP calendar is going to be March the 25th. Position number 1 is reset further notice with a $3,000 SOB through pretrial. Position 2 is reset further notice with a $2,000 SOB through the jail. Position 3 is reset further notice with a total $3,000 SOB through pretrial. Position 4 is reset further notice with a total $9,000 SOB through pretrial with a co-signer of Anna Chavez. 5 is reset further notice with a total $1,500 SOB through pretrial. 6 is medically reset till tomorrow. 7 is reset further notice with a $3,000 SOB through pretrial. Position 8 is reset further notice with a $3,000 SOB through pretrial. 9 was heard on yesterday. 10 is a medical reset till tomorrow, March 12th, and it is a medical reset. 11 is going to the SAP calendar with a total $4,000 good bond. 12 is going to the SAP calendar with a $500 good bond. 13 is reset further notice with a $3,000 SOB through pretrial. 14 is going to the SAP calendar with a $2,000 total good bond. 15 going to the SAP calendar with a total $3,000 good bond. 16 is reset further notice with a total $2,000 SOB through pretrial. To the add-on calendar, position number 1 is going to the SAP calendar with a total $2,500 good bond. Position 2 is reset further notice with a total $5,000 SOB through pretrial. And position number 3 is going to the comp calendar on March the 27th with a $2,000 good bond. Are there any questions, comments, or otherwise?
Your Honor, I believe the person iPhone is actually Mrs. Brown. She's unable to unmute herself. She's the victim in Mr. Watkins' case, that sexual battery.
So if Ms. Brown can hear me, if you'll, Ms. Allen, if you'll have your victim advocate reach out to her at some point if she needs an explanation as to what's going on today.
Well, I think she was here. We spoke to her. She was trying to chime in when you called for her when the case was heard.
All right, very good. If nothing further, y'all have a good rest of your day. We'll see you next time.
You too. Thank you.
Goodbye, everyone.
Goodbye.